Hello, this is Matt on the Moon Lambo channel, and here's a curious story for you. This headline comes from the Crypto Basic. Anonymous third party seeks changes to Ripple's summary judgment motion to protect its employees' privacy interest. And part of what you'll see as I go through this story, which is the first thing I'll cover in this latest Moon Lambo hot jam, there's certain information that this anonymous third party does not want Ripple to make public. And then there is also this headline from You Today. SEC v. XRP. Lawyer explains how Chamber of Digital Commerce will help Ripple and XRP. So we've been speaking in recent days about the impact of the Chamber of Digital Commerce injecting itself in the SEC v. Ripple case by way of filing an amicus brief. And my opinion is that it's a positive. It's very good. There's an attorney who I follow and respect within the XRP community, and I highlight what he has to say fairly frequently. And he's not actually quite so confident that what was filed is actually good for XRP specifically. Set aside Ripple even, but not even so sure that it's actually good for XRP. And I'm going to give you the full context of what he had to say. And I'll tell you this too. I agree with a fair bit of what he had to say. There is one particular thing where I actually do respectfully disagree. And but now, of course, he's the lawyer, so I'm not saying take my word over his. I just think it's fun to talk about this stuff, and I love thoughtful discourse. So I just respectfully disagree on one point, and it's the point where he's saying that this is not necessarily good for XRP. But I'll share with you the specifics in due course. Before going further, I do want to be clear: I do not have a legal or financial background of any kind. I'm not offering legal or financial advice. And you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Okay, into this first piece. Who is this anonymous third party trying to prevent Ripple from letting out specific additional information to the public? In a bid to protect the privacy interests of its employees, an unidentified third party has requested limited redactions to Ripple's summary judgment motion filed 2 days ago. And here's a quote. "We write on behalf of third party A to propose a limited number of targeted redactions to the defendant's memorandum of law in support of their motion for summary judgment." End quote. So that's what the unidentified third party stated in a motion filed just yesterday. And a shout out and credit to James K. Filan, who is an attorney within the XRP community. And he simply wrote the following in describing what this document is about. He said, "An unidentified third party has filed a motion to seal portions of the Ripple defendant's motion for summary judgment that references the names of the third party's employees." Piece continues. "According to the letter, the anonymous company had made a similar request previously to redact the name of its employees from the exhibits filed in connection with the party's Daubert motion. The unidentified third party stated at the time that the reason for the request was to protect the privacy interest of all company current and former employees." And here's a quote. "The summary judgment motion, like the Daubert motions, references the names of certain third-party A employees. Accordingly, for the reasons articulated in our July 28th letter, we request redaction of the references to third-party A employees in connection with the summary judgment motion." And that was the quote. And then they state here, "Notably, the party also added a copy of the proposed redaction under seal." So here's the thing. Like, I'm always happy to engage in healthy speculation. I think that that's perfectly reasonable to do. In this particular case, I'm just going to be real with you here. I have no idea who this anonymous third party is. And I never pretend to know everything anyway. But I'm wondering if any of you have any additional pieces of information that maybe I'm unaware of, or any speculation as to who this might actually be. Because this is one where, I mean, and I even asked the question on Twitter. And at the moment that I checked it anyway, I didn't really see anything where there was like, any notable evidence, at least at that particular point in time. But maybe somebody out there more times past now, maybe somebody listening has an idea of what this might be. And if so, I would absolutely love to hear from you. But then there is also this from You Today, SEC v. XRP. Lawyer explains how Chamber of Digital Commerce will help Ripple and XRP. And so there's this thread from Attorney Bill. I'm a big fan of Attorney Bill. I always appreciate his insight. I appreciate all the attorneys within the community because they make this complex legal stuff understandable for regular people like myself and most of you listening. And without them, we'd be much more so in the dark, and it would probably be for many people a lot more nerve-wracking in terms of what's going on. So certainly appreciate this, but there is one thing that he stated in here, which I already referenced at the outset of the video, where I just respectfully disagree. And if you think he's right, cool. And if you think that what I'm saying makes sense, super duper. Or maybe you've got a third point of view that neither of us has considered. Again, I love thoughtful discourse, so feel free to share what you think in the comment section below. But I want to put out in the entirety of what Attorney Bill articulated. And I do think, even though I disagree on this one thing, he makes sense here, like to me, other than this one little thing. So anyway, here's what Attorney Bill had to say. I have seen a lot of comments about the Chamber's amicus brief not helping Ripple, but being good for XRP holders. To a point, this may be correct. The Chamber wants the court to differentiate between the transaction involving a digital asset, which may be an investment contract. So I'll just pause and note, when this news broke, and I was very excited to see this, that the Chamber of Digital Commerce actually finally filed the damn thing after teasing us for about a year. Well, I did a full breakdown, so that's not the purpose of this video, but it is worth understanding that one of the things that they were really getting at, and the Chamber did a great job of breaking this down in my humble opinion, which is the right way to say the word opinion. Why do you say opinion weird? It's opinion. They were talking about how something can be an investment contract by the nature of the scheme that's in question, but that is separate from the underlying asset itself by the nature of it existing being a security. And that's a crucial difference. Just like in the Howey case, the scheme was found in 1946 by the Supreme Court to represent an investment contract, but that doesn't mean that oranges themselves, by the nature of them existing, are investment contracts. And likewise, it doesn't mean that those same orange groves couldn't at some point be sold in the future, a secondary sale, and it doesn't mean that that every single transaction having to do, since that was ruled on in a case, it doesn't mean every single transaction, even on secondary markets, forever, would represent an investment contract. If it's a completely unrelated scheme, it's just secondary market trading, that doesn't make sense. And so that was a point that they really articulately fleshed out. Anyway, Attorney Bill continues. Let me just restart this so that I got the proper flow. I've seen a lot of comments about the Chamber's amicus brief not helping Ripple, but being good for XRP holders. To a point, this may be correct. The Chamber wants the court to differentiate between the transaction involving digital asset, which may be an investment contract, and an asset itself, which the Chamber wants the court to see at least from some point in its life as a commodity. The Chamber wants the court to realize that whether a transaction involving a digital asset is a security and whether the asset itself is a security are separate inquiries. The exchanges would be happy if the court drew a line at offers by an issuer or promoter and not find digital assets themselves to be securities in most instances. The exchanges would be happy with the Chamber's arguments. It would mean much secondary market trading doesn't involve a security. What the Chamber doesn't want is a precedent in the Ripple case where the court finds that today's XRP is a security without making separate inquiries that differentiate between Ripple's transactions involving XRP and XRP itself. This would be conflating the Howey contracts with the oranges. Such a finding would be bad news for many cryptos and most US exchanges which listed XRP. However, the Chamber will have achieved something positive even if the court finds Ripple sales were investment contracts and today's XRP in the specific facts of this case is a security, which would be a bad result for XRP holders if the court at least recognizes that there are two separate inquiries to make both inquiries in this case. So think about it. So my understanding of the way that he worded that is he's saying even if they differentiate between the two things, the actual scheme at question and the asset itself, even if they do distinguish between those two, the court could still come to negative conclusions and rulings on both of those, even if they differentiate. My understanding is that that's what he was getting at. And then Bill wrapped up the thread by stating, therefore, I don't look at the Chamber's brief as good or not good for Ripple or XRP holders. I do think it important and good for the case if the court accepts the difference between Ripple's transactions involving XRP and the asset itself and recognizes the different inquiries. And so here's what I would say on that. If Judge Torres does end up recognizing that specific sales of cryptocurrencies are separate from whether the underlying cryptocurrency is a security, that would be a positive for XRP. And the reason I say this is because if that distinction is made, and per the Supreme Court's 1946 ruling, the distinction must be made, well, then XRP will end up not being viewed as an investment contract. So on that point, I slightly and respectfully disagree with Attorney Bill. If the Chamber of Digital Commerce's amicus brief persuades the judge to recognize the importance of this distinction, I personally believe that will directly help XRP, though I acknowledge that the judge could come to a poor conclusion. So the reason I say this is good for XRP, and this is where thoughtful minds can respectfully disagree, it's because I think that the evidence to this point is so overwhelming that the nature of a thing existing doesn't make it a security. And so that's why that's the primary reason why I'm stating that, while acknowledging the point that Bill's making is good. Like it's perfectly reason to suspect that even if you differentiate between the two, you could still get a bad ruling on both. So that's why I understand that he ended up saying what he's saying. I'm just saying that even though I recognize that, so hopefully it's clear that by reiterating this and wording it in slightly different ways, that if that happens, fine. But if the distinction is going to be made, and it should be made, I do think that's good for XRP. Doesn't mean it will be, but that's my supposition, is that it would be good for XRP. Let me know what you think in the comment section below. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. So that would be a very, very, very bad idea. Until next time, to the moon, Lambo.